rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in Shaw versus Arizona Board of Dental Examiners. Our cause number 1CACV 13-0488. Counsel, I'm required to advise you that we're being video recorded today. In addition, as you probably know, we have met, conferred, and reviewed fully the briefs and record in the case, so you can bear that in mind as you begin your presentations. Each side has 20 minutes for oral argument. The appellant is free to reserve as much time as you like for rebuttal, but you're responsible for watching your own clock. And with that, we can begin.
May it please the court. It is undisputed that the Arizona State Board of Dental Examiners did not give Dr. Shaw notice regarding any of the allegations, did not give him notice regarding the standard of care to which he was going to be held, and did not give him notice regarding how any breach of the standard of care had affected this patient. That's undisputed. And what we know is that when we look back at the timeline, there are cases before GAVIC that talk about a person's right to due process in an administrative proceeding. And that right to due process includes notice and a right to be heard. And then GAVIC is decided in 2009. The Board of Dental Examiners knows about it and even discusses it in executive session in February of 2010, 14 months before Dr. Shaw's investigative interview. That's the backdrop against which our appeal lies. Because what we know is that the board raised, for the first time, at that investigative interview, multiple issues that Dr. Shaw had no reason to expect were going to be asked, and for that matter, no ability to prepare in terms of who he needed to bring in, whether it would be his staff, expert witnesses, medical literature, anything along those lines.
So you disagree with the board's position stated in their appellee's brief that he was given notice at the interview level, I believe, but when the decision was made by the board itself, he brought witnesses and wasn't able to put them on. Is that the way that worked?
Well, if I understand your question, the notice to Dr. Shaw essentially said, we're going to investigate an adverse occurrence and reporting of that adverse occurrence. It wasn't anything along the lines of, we're going to ask you about whether or not you adhered to the ACLS protocol and the pharmacological aspect of it, or whether or not you are aware of the black box warning for droperidol, or whether or not you printed out an EKG. None of that came up. None of that was raised until the investigative interview, which, this might be subjective, but I know when I read the transcript and listened to the tape, instead of being an interview, it was more a prosecution or a persecution.
Well, okay. Persecution might be a little strong for somebody who had to do continuing education, but is it your contention that this was discipline?
Oh, absolutely. This is a disciplinary action against Dr. Shaw, and that's where the prejudice
what statute
lies.
do you base that on? Is it subsection A or subsection B?
It's based on the board's finding that this is a disciplinary continuing education, which means it's reportable to the National Practitioner Data Bank. It's reportable in any credentialing, applications to participate with health insurance companies, with malpractice companies. And it's prejudicial because the plaintiffs in the wrongful death action that arose out of this are relying on the board's findings.
Well, counsel, 1263.01B says the board may issue a letter of concern, which I understand you were actually asking for that, but that did not happen.
Yes.
That did not happen. But in the second sense, the board may also issue a non-disciplinary order requiring the licensee to complete a prescribed number of hours of continuing education. Didn't that occur here?
It was disciplinary continuing education in this case.
Why is it why is it a disciplinary order as opposed to non-disciplinary? That's what the statute says, non-disciplinary. Is it clear what the board did here?
Our impression and understanding all along has been that the board issued this as a disciplinary continuing
Did it
education.
say disciplinary continuing education? Because I don't recall seeing that word in its finding or order.
Well, we have requested repeatedly
Well,
in
did
our
it?
motions.
Is that word in there or not?
I would have to go back and check on that. Our position has always been that we did not want this to be disciplinary. The board took that position that it was. I will reserve that time in rebuttal to come back to that.
Of course, you understand, if it's non-disciplinary, then there's no right to appeal. There's no right to under the Murphy case, I believe, there's no right to judicial review in the Superior Court.
If it were non-disciplinary, presumably the State Board of Dental Examiners would have been all over that and said there's no reason for this whatsoever at the trial court level and here. That issue, they'd never have taken that position.
Well, I think it could have been disciplinary. I'm not suggesting that it wasn't, but it is possible to read subsection A, which is a disciplinary provision, as applying in this case. It's also possible to read the non-disciplinary provision of subsection B as applying, and I don't think the board made clear what it was doing, which is why I asked the question. The fact that everybody may have been assuming one thing or another isn't necessarily dispositive.
Well, Your Honor, as I mentioned, I will reserve my time to find the board order, which is in the record, and refer to that in my rebuttal.
That would be helpful, counsel.
All right. Beyond, the issue, when we look at the entire course of this investigation, we see that, and I know the board makes little of it, that Dr. Shaw wanted to have the lawyer who had represented him before at the meeting. And the board makes little of, well, they were not going to accommodate council schedule, we didn't provide dates, and so on. As a practical matter, when we did provide dates, and we said, just if you could postpone it more than 2 days beyond where you have it now, the board said, it is our custom to just reschedule it to the next one. So regardless of the next date, regardless of whatever dates, based on the email, which is Exhibit 7 in our index to our opening brief, the email that the board sent said they were just standing on their custom, which really ultimately is what this case comes down to. The board throughout this has stood on their custom instead of recognizing the constitutional rights of a licensee to due process.
Where is the constitutional implication of having a different lawyer from the same firm represent you at an administrative hearing, especially one that your client concedes was highly competent? How is that unconstitutional?
Well, because when you combine that with the lack of any notice and the ability to prepare, that then makes it doubly difficult for a lawyer who's otherwise qualified and competent, but who has never attended one of these investigative interviews before, which I'm glad they don't do them anymore because the procedures were all over the place when they did them. But that puts an incredible burden on counsel for the licensee in this case.
And do you have any case authority for your position, that that's an abuse by the board?
Well, under these circumstances, when we combine it with the lack of notice and the board's unwillingness to schedule it at a time when he could have been represented, by the counsel of his choice, granted in the same firm, that means then in any firm, ultimately we're, basically treating lawyers as being entirely fungible. And so you could go however far down the line and say, look, we have somebody here who's never done anything, but they're free that day. And yet the only reason that the board cited for their unwillingness to reschedule it was, number one, their custom, and number two, the convenience of the specialist who was going to participate. So they had no significant reason for not giving the doctor an opportunity to have all of his constitutional due process rights at the investigative interview.
Well, we haven't yet resolved whether this was even disciplinary, but assuming for a moment that it was, given the sanctions at stake here, what exactly were his constitutional due process rights? Because as I understand it, there's a bit of a sliding scale. Termination of the license would require more due process. Continuing education, maybe not as much.
Well, when we look at Gavick, which talks about notice to the licensee of the standard of care, well, the allegations, what the standard of care is considered to be, and how any breach of the standard of care would have or could have injured the patient, I don't recall there, with all due respect, there being a sliding scale in terms of the notice that is provided to the licensee. All we're asking for is that Dr. Shaw should have had notice. He should have been told coming in so that he could have been prepared to respond to the allegations regarding the EKG strip, the droperidol, the pharmacological aspect of the ACLS algorithms.
At some level, isn't it fairly self-evident that given the fact that a patient died under sedation, pharmacological aspects are probably going to come up? I mean, how specific does the board really have to be to comply with the Constitution?
At a minimum, the board could have said, we are going to question you about whether or not you complied with the recommendations.
And if it had said that, what would have happened differently?
Well, what we would have done is we would have shown up with evidence, and Gavick recognizes you can have expert testimony, including an outside expert, cardiologist to say, you know what, as a practical matter, there is a very, very, very almost minutely small chance of surviving a heart attack, even when witnessed, even when the CPR is performed, even when these medications, which there used to be two, now there's one because one of them accomplished nothing.
I don't want to take up your time outlining the proffered testimony. I get what I'm really getting at is what about this scheduled proceeding misled your client and counsel into thinking that these issues wouldn't come up and they didn't have to come prepared?
Well, if I take what you're saying at face value, then Dr. Shaw should have been prepared for any possible eventuality, and that Gavick, in his case, and the right to notice simply did not apply. And so he would have had to have been told nothing specifically about.
I'm asking a factual question. I'm trying to understand the decision process. That if this relatively innocuous notice that you suggest should have been provided, we're going to talk about pharmacology at this interview, which again, to me seems like a fairly easy inference to draw in these circumstances. If that notice had been provided, your client would have come in with expert witnesses. But are you suggesting that the absence of that sentence in the board's notice caused your client to somehow become complacent and believe that there were going to be no issues of substance discussed?
Not at all. But anybody being interviewed in this type of setting where there is something as significant as the licensee's professional license to practice in the state of Arizona should have the opportunity to prepare for whatever it might be. And here's an example, the droperidol issue. We have this board expert witness, the consultant, who wasn't, as the board tries to make him out to be, an administrative law judge. He assumed the mantle of a prosecutor without telling Dr. Shaw what he was being charged with. He walks in and says, you shouldn't have used droperidol, and you should have used these other two medications. Had we been told that that was the standard of care, we would have then been able to respond at the investigative interview, and not just at the Board of Examiners at the full meeting when the issue was a foregone conclusion. We would have been able to respond that, you know what, the two medications that the oral surgeon, who the board has hired, says we should have used because there are no side effects. Well, it turns out there are the same side effects with those medications. So that's the kind of thing where unless somebody has an encyclopedic knowledge of whatever eventuality might come up, then we're at a disadvantage walking into that investigative interview with no notice of what the issues.
Your client himself knew why he chose the medication he chose.
That's right.
And was prepared to address it.
He was the one person that was present when the event occurred.
He knew the medication, and plaintiffs had made much about, well, were you aware of the black box warning? In the investigative interview from April 20th of 2011, he says, I was aware of issues with the medication, but I administered it at a low dose. And here's the problem. We have somebody saying, well, and this is in the board's brief as well, where they say, instead of doing the 12-lead EKG, Dr. Shaw settled for a negative cardiac workup. Well, if we had known that was going to be an issue, because there's nobody saying that played a causal connection at all, causal role in the outcome, we would have gotten the cardiologist records, which we now have in the wrongful death case, which show that he did have a 12-lead EKG, echocardiogram, and stress test, all of which were normal, none of which showed the potential arrhythmia that can cause a problem if you give droperidol at a much higher dose than Dr. Shaw did. That all is information we didn't have an opportunity to present at the investigative interview because we didn't have notice.
So, counsel, as I understand it, you now are in possession of information that contradicts your client's earlier statements about only having a 3-lead EKG, not having tape. I mean,
No, not at all.
You just said he had a 12-lead.
The cardiology records In the cardiology records, the workup that Dr. Shaw relied on when the patient said he had had a cardiology workup, his cardiologist obtained the 12-lead EKG, the stress test, and the echocardiogram, all of which were normal.
And Dr. Shaw relied on that before performing the procedure.
He knew that this patient had had a cardiology workup before the procedure.
And did he review those records before?
He did not.
Okay. So if that's the body of evidence pertaining to his own due diligence before performing the procedure, surely it wasn't so much of a surprise that he couldn't have said that. I mean, he couldn't. He could have simply said, "I knew that there had been an echocardiogram and a 12-lead EKG, a stress test, and the results were negative, and I decided to go forward." There wasn't much to add in terms of the contents of those documents because he hadn't reviewed them.
Knowing that the patient had been evaluated by a cardiologist, Dr. Shaw reasonably believed that a 12-lead EKG had been done, and it turns out he was correct.
Okay, but
And
how hard is it to say that at the hearing with this level of notice? It doesn't strike me that any deficiency in the notice would cause him to be unprepared to say what you just said. And then whether that's ultimately persuasive on the merits is another question, but we're talking about notice here.
Well, notice, as I mentioned before, gives a person an opportunity to prepare. And we have spent months and years reviewing and analyzing and going back over the volume of material in this case to where we've gotten to today. So we can all talk about what Dr. Shaw could have said under the circumstances. What I would appreciate you considering is him walking into this situation with no notice whatsoever about the particulars that were going to be raised, about the false information that was going to be presented, and then not having an opportunity to rebut it. Those are entirely two different situations where you're being confronted with somebody who's saying the conspicuous absence of an EKG from your records, the regulation in question that wasn't brought up until the interview doesn't even say that a printed EKG is required. So those are the kind of things where, I suppose in retrospect, with the benefit of as much time as all of us have had to review this, some things might be, quote, self-evident. On the other hand, a licensee going and confronting a hostile oral surgeon who is pulling things out of the air about which he knows and has had no notice, that's an entirely different story, where if he had this to do over again, absolutely. Knowing what we know now, I suppose it would be another ball game entirely. But nobody has made that offer, and that would be the fair thing to do. But that wasn't available, that opportunity to know what he was being confronted with, to be able to respond substantively, wasn't afforded him. That's the notice that is required, the due process notice that's required. The board doesn't dispute that they didn't provide it. That's undisputed. Basically what the board is doing is asking you to insulate their refusal to provide notice and what ultimately is their knowing and intentional disregard of the court's ruling in Gavlik. That's what the board is doing. They're not saying that they would have acted differently if Dr. Shaw had been able to respond substantively with no notice. They're not saying they would have acted differently if we had said, hey, by the way, at any point along the way, here's what we need to know. All they're saying is, you can't hold it against us that we disregarded the case law leading up to Gavlik that says a licensee has the right to notice. And without further questions right now, I'm going to reserve whatever remaining time I have. Thank you.
Very well.
Good morning. Michael Rain, Assistant Attorney General, appearing on behalf of the Arizona State Board of Dental Examiners, and may it please the court. The primary issue I want to focus on is the due process issue. I think that's probably where you'll have the most questions for me.
Can we just cover the question that I think your colleague is now
The disciplinary.
checking? Yes, whether this was disciplinary in nature.
When I think that the discussion was correct, that perhaps it was always assumed that it was disciplinary, and that's record item.
Well, where does that leave us?
I understand.
A common assumption doesn't put Dr. Shaw in a very clear position when it comes time to assess his reporting obligations when there's a perfectly legitimate reading under the statutes that suggests this is non-disciplinary.
I understand that, and when I look at the record item, I believe it was record item 21, the board's order, my read of it is that it was disciplinary. It says that this misconduct was grounds for, and in all caps, disciplinary sanctions. So I'm not sure that the record's going to answer that crystal clear for you, but from what I see in the board's order, as I stand here today thinking about it the first time, it references the word disciplinary, and so I would say, at least for argument's sake, I'll proceed on the idea that it is a disciplinary issue.
And so we're clear on this, then the board's position is that this has been an action against his license and not just a non-disciplinary letter of concern or direction to take CLA. So it would potentially be used against him in the future.
I think for argument's sake, I have to take that position from what I can see here on the fly, and in that order it says disciplinary, and I'll be honest, that's the way I viewed it going into the case, and not because I deliberated upon it, but just because of the nature of the due process issues. It was maybe overlooked, okay. And it's an interesting point, and perhaps it would need clarification in the record if it can't be found. But the issue I do want to focus on very briefly before I jump into the due process issues is the evidentiary issues, because I think it provides a good context for the rest of the discussion.
Evidentiary in light of the due process issue?
Just evidentiary, just to discuss the nature of the board's findings, because I think that essentially there's been a straw man argument raised here by the appellant. When you hear about, for example, the drug droperidol, there's talk about, well, we could have brought someone in to talk about that was the appropriate drug to choose, that the alternatives had their own problems. But when you look at what the board and the panel have actually found, it wasn't that droperidol was the wrong drug. It was that he did not read, Dr. Shaw did not read or know about the black box warning label with that drug, and that is the dangerous condition. You'll see in the transcript repeated reference from the panel that we don't think that using droperidol had a causal effect on the death of the patient. I mean, maybe 10 times they say that. So the issue isn't whether droperidol is the right drug or whether it was administered in the right doses at the right times. The issue is, did you read the black box warning? The same logic applies to the ACLS life-saving protocol. The question wasn't, if you had followed this protocol, would you have a different outcome? The panel clearly says it doesn't appear that there was an option, that we had a serious, and later evidence showed, a serious heart attack here that would not have changed had you followed the protocol. And I think that's not after the fact. In the panel's discussion, they say that very specifically, and the fact that they do find is that you didn't follow the protocol, and that's a dangerous condition, not to follow that very well-known protocol. And I think if you look in the transcripts and in the briefing, there's no dispute from Dr. Shaw that he knew the protocol, the pharmacological aspects of it, and that he didn't follow it. Similarly with the records, those are static. They can't change. And the board's findings that there were some gaps in the time, 10, 20-minute gaps here and there, and some inconsistencies about when drugs were applied and at what time, it's a records violation. Records, of course, themselves don't have any causal connection with the death of the patient. So when you look at all the facts that were found, I think the key point I'd like you to take away is that it's not going to be a whole new ball game, as counsel suggested. It's really going to be a replay of that game, because it's not as if Dr. Shaw is going to come in a remand and say, no, you know what, I did read that warning label. I did follow the protocol. My records, I have additional records. All of the facts that were found, they came from Dr. Shaw, and they come with certainty, and Dr. Shaw was very candid with the panel. And he's never wavered in any of those positions. And I think that it's important to note that no matter what notice was given in this case, those issues would never have changed. And it all came from Dr. Shaw's own personal knowledge, and they've never wavered from that. And I think that that's where this ties into the waiver issue and the due process issue. Now, the state has two arguments on the due process issue that they've briefed extensively. One is that the issue had been waived. The other issue is that there was no prejudice from it. And following on that discussion of the evidence, I think you look at, could there have been a prejudice? If he had had that notice, what else would have happened?
Back up, counsel, just a second. Are you agreeing then, or that the notice could have been, that the notice was insufficient under GAVIC? Or did it comply with what GAVIC contemplates?
I'll certainly agree that the notice could have been better. I mean, that it could have gone into more detail. And I think, in my impression of reading the record over and over again here, is that essentially That investigative panel is also a bit of a fact-finding panel. And so to some extent, maybe the notice couldn't have been better because of that issue. But I think under Gavick, more would be desired. Now, I'm not prepared today to say we waive that issue and the notice was insufficient. I think there are some distinctions in this case between this case and Gavick, in the sense that Gavick and Webb are both cases that really are standard of care cases. Did you make the right decision between two alternatives? Whereas, as I noted in the evidentiary discussion, this is more of a black and white case, more of a per se negligence or a strict liability sort of theme to this case, where it's, did you read the warning label? Did you follow the protocol? And what do your records say? You can have other people come in and look at those records, other experts, but the records are what they are, and Dr. Shaw is not going to have an expert come in and say that he did something that he's claiming he didn't do. And so that straw man argument that they keep raising is that we could have come in and explained that with experts and addressed all this stuff, but no expert's going to change the actual facts that were found, regardless of the nature of the due process provided. They were found, and they'll never change. It'll always be that he didn't read the warning label and that he didn't follow the protocol, and that his records were as such. And I think that not only do you see that prejudice logically, but you see it in the actual transcripts and the records, because many times, I counted up to 13 times that Dr. Shaw and his counsel appeared in formal ways to the board, either writing letters to the board in response to allegations, requesting information, or appearing in person. And you will not find a single instance where Dr. Shaw expresses any confusion, asks any question about the nature of the allegations, nor, of course, given that, will you find any objection to it. And so if there really was shock and confusion, you would have seen something, some hint of it. And I think in a large part, you actually see him right in line with the board, a very knowledgeable doctor. When they're talking about the ACLS protocol, Dr. Shaw, they said, did you apply the drugs? Normally you apply, and Dr. Shaw jumps right in. Epi, atropine, I'm not familiar with all the drug names, but he knows the drugs. He knew how to answer those questions. All that information was within his personal knowledge.
Counsel, so are you saying that rather than the impression that there's an interview and then there's the review of the decision, that this was more of an ongoing dialogue? You say 13 times there were communications back and forth. For instance, was there an interview and then a follow-up that said, I was asked at the interview such and such, and I've been able to put this together, and here's my response to that? Was there any of that went on?
Not really a back and forth in that way. Now, what happens is he gets notice, the notice in this case, he gets the notice of the adverse occurrence. His counsel submits a lengthy written response. Nowhere in that response do they raise any due process issues. Then they appear before the panel and have a discussion. They don't raise it there. Then they receive the panel's report. Right. Now, that report then goes to the board for a review. They write a written response to the report, essentially, to the board. They don't raise it there. They appear before the board in its review. They don't raise it there. They file a motion for a request for rehearing, where in that request for rehearing, they raise 10 different grounds, most of them due process issues, for review, but not this issue, not the Gavick issue. They also appear in person, and they don't argue it in person. Even further than that, and I think this is a key question for this court, it's almost jurisdictional, I think, in nature, because then you get to the judicial review stage. Complaint for judicial review and the opening brief for judicial review, it doesn't bring up this issue. This issue, the entire Gavick issue upon which their entire case is founded, all of their disputes about the evidence are also founded on this issue, because they say you can't rely on any of these facts because the whole process was flawed, notwithstanding the fact all the facts come from Dr. Shaw. They don't raise that till the reply on appeal to the Superior Court. So the board has never, before it briefed this court, had the opportunity to address that Gavick issue. And that's the waiver. That's the waiver question. And I can't think of a better argument for waiver than to say you've had 13 communications with the board, formal briefs, you've even gone up on appeal and failed to raise it. And now what I suspect occurred is that in response, in the first level of appeal to the Superior Court, our office cited Gavick for a general proposition of law. And I imagine that counsel read that and has honed in on that. But that's too late. If that's not waiver, then we're on the second level of appeal here when they're raising it for the first time. And I think when you look at the case law that's been cited, you don't even have to go that far, because issues not raised in an administrative context at the administrative level are waived even before the Superior Court. And here we not only have that, but we also have them not being raised at the Superior Court level. So this is the first body that's even been presented that question. So, I mean, that's essentially the nature of the due process issue. I do agree with the court in its questioning about a bit of a sliding scale on due process. I think when you read those cases, the severity of the outcome does play an impact, and we really do just have continuing education here. And I understand that there may be some motives for challenging this head on and really fighting against it, but what we have here is a proceeding that all of the evidence that was gathered, all the fact findings come from Dr. Shaw. The conclusions are not that Dr. Shaw caused the death of this patient by any of the allegations, and merely continuing education on issues such as reading warning labels and the ACLS protocol. So this isn't the case that they've set it out to be with regard to this mountain that the board had to overcome to prove, and all of this information that Dr. Shaw could have come in. He knew the moment that procedure was done the answers to all of the questions that the board asked. There's a few other points I'd like to address, such as that Dr. Shaw was denied due process because he wasn't allowed to present witnesses. And when you look at the reason that he wanted to present those witnesses, it was to fill in the gaps in his records. And I think just standing alone, that tells you that the records had issues. If you need to bring in 3 people to tell you what happened in the spaces in your records that no one knows what happened, that demonstrates that the records had issues. So I don't know that that's a prejudice, not being able to have those witnesses. But let me take a step back. Dr. Shaw could have brought those witnesses to the informal interview. And when he gets that notice of the...
How did he know that?
Well, because it said so. It said expressly so in the notice of informal interview. And that's a key distinction between this case and Webb. In Webb, it was kind of a take it or leave it. Here's an informal interview invite, come and go. And the court, this court in that case said, you can't waive something when you really didn't know you had an option. You knew you had an option in this case. And in the notice of informal interview, which I'll try and get you the, I think it's record item 13 from the administrative record. But what you see is multiple pages of advising Dr. Shaw, you have the options, informal interview or formal interview. But it went further. It said at the informal interview, excuse me, should you choose that path, you have the right to present evidence, to question people, to give testimony. It also said you have the right to ask questions in advance of that hearing. And it even gave him a form for doing so. And Dr. Shaw's counsel, to their credit, repeatedly asked for information and records, but never once raised this question. And I think the undeniable conclusion is that because they weren't really confused about what they might be talking about. It was this case.
So I understand, leading up to the interview itself, there were numerous exchanges about needing information and what was going to happen and how the matter was going to proceed?
There were, and those are in the administrative record. Okay. I counted, I believe it was 5 requests for information, written requests for information with responses from the board. And obviously the initial notice to Dr. Shaw that he was allowed to do so. And they seized upon that opportunity, just as they seized upon every opportunity to raise due process issues in this case, but never once raised GAVIC until reply at the first level of appeal. So the idea of presenting witnesses, I just don't think that would have changed anything. But nevertheless, he had the right to present those witnesses. With regard to the counsel of his choosing, I'm not really sure where to go with that other than to say there's no case cited for that. And that clearly there's no argument that there was a prejudice from that because they haven't articulated that this attorney fell below a standard. And so I don't see anywhere with the counsel of choosing that this court would have at least a precedent on which to rely. There's another issue about the rescheduling of the hearing. And obviously that's a discretionary decision with any adjudicative body, how to manage its own calendar. And in this case, it's not as if they reflexively denied it. They granted the request for an extension. A second request for an extension came in, and I'll disagree with counsel here to say that they just stood on policy. And if you look at the email that comes back to counsel for rejecting the second request for continuance, they say, first of all, this is our policy. I'm not going to deny that they do say that this is our standard policy. We're not treating you any differently than anyone else. But also, we have panel members who have been scheduled, and now they've been rescheduled to this date, and this is a date they're available. So they're managing the calendars of multiple people, and they've simply denied a second continuance. And I guess I'm not sure that one court would want to substitute its judgment for another adjudicative body's decision on how to manage its own calendar, given that same court granted one continuance already. And there's no case law cited for how that could be a per se due process violation. I think when you look at some of the briefing, one thing I'd like to point out is the cases on due process that the board cited. There was a lot of attempts to distinguish those cases as on waiver, I should clarify. But if you look at those arguments, none of them are that great. In one case, they said, well, in that case, the gentleman was an aggrieved party, and this gentleman's not an aggrieved party. And I just didn't even understand the argument because, of course, the party objecting on a due process basis is the aggrieved party who may have waived it. I didn't understand that. There was a case, the Neal case. They talked about that the board didn't have jurisdiction to hear a due process issue, where I think if you look at that case, they did. They had the same administrative rule that this board had for requests for rehearing. The number one ground in request for rehearing before the dental board and in the Neal case is irregularity in the proceedings that deprive a party of a fair hearing. There's really just no genuine attempt to distinguish any of the cases, and I think I want to make it clear too that there's two levels. You don't raise it at the administrative level; it's waived for the Superior Court, but in this case, it was not properly even raised at the Superior Court level. And so at the end of the day, what we have here is a case where continuing education was issued because the board found that not reading warning labels on drugs you're administering, not following the well-known ACLS protocol, and having records, essentially, that leave gaps and require witnesses to come in and clean those up, those are dangerous conditions. And I think that this case is somewhat distinguishable from the Gavick and Webb cases, in that those, as I said earlier, are essentially per se negligence cases. And you even see in Gavick they uphold one of the claims, notwithstanding the poor notice in that case, because it was a violation based on statute. And in this case, you have a violation with the records that's based on rule, essentially. I mean, the rule is what requires you to have the records, and kind of a per se negligence that a layperson can understand even about not reading warning labels that apply specifically to the drugs you're giving, and not following the ACLS protocol. So when you review this record and you go back and you look at the transcript, I want you to look and see that they have not held Dr. Shaw, the board and panel did not find Dr. Shaw caused the death of this patient. They found that he didn't do things that he agrees he did not do. So the facts are reliable. This court is supposed to give great deference to those facts found by the agency, but I don't even think you need to go that far because they're essentially undisputed facts that form the basis of the board's order. On the discipline or non-disciplinary issue, it's an interesting question, and I think it would change the notice requirement, but I don't think that even if you find it is disciplinary from reading that order, that it changes our arguments, because as I said, that's essentially how we've assumed it to be. And so I have a minute left. If you have any questions, I'm happy to answer them.
Thank you.
Thank you.
Your Honors, in the brief time I have left, number one, I have not cross-referenced it to the record, but the board's June 10th, 2011 order says that under conclusions of law, that the issues in question constitute grounds for disciplinary sanctions under ARS Section 32-1263, Parent 1. Next point. As many communications as counsel for the state says there were between my office and the board, I'm not going to dispute him. I'm not sure exactly what he's referring to. All we know is that with all those multiple opportunities to say what the allegations were, the state didn't do it, even though they knew they were required to.
So you're agreeing that Gavick was never raised in the administrative proceedings, correct?
We did not raise Gavick by name. We did raise when we replied to the board to say why the board should not follow the investigative interview panel's findings. We said, here's what we're addressing for the first time, because it first came up there. Here are the issues, and here's how we're responding to them substantively. We couldn't do it at the investigative interview because we didn't know about them then. Here's what we're saying now and why we'd ask you to consider it. But at that point, and we're saying it didn't matter.
Well, if counsel was in doubt as to the nature of the allegations, the standard of care, any Gavick issues, why not simply ask the question? Why sort of keep that issue secret and wait for the board to fail to utter magic words.
Well, I don't think the onus is on us under those circumstances. It's like saying to a defendant, why didn't you ask for your Miranda warnings? We would have convicted you anyway. It doesn't really matter. We're not going to recognize that you have constitutional rights unless you raise them at some point. And here we have the state of Arizona.
Well, this
knowing
isn't a
full
criminal
well-
case, and I think it's more akin to a request for clarification or simple discovery. And this is an informal process.
Well, Gavick did not turn on that. They didn't say that it was Gavick's fault that he didn't know, he wasn't clairvoyant. And they said, no, this is what the state has to do for the purpose of meeting due process notice to the licensee. And here's an example of where, what are we talking about in this case? We end up with this EKG issue. The regulation doesn't say anything about you have to have a printed EKG strip. We end up then at the board hearing 2 months later, and we have Dr. Gradke not saying what the statute, or rather the regulation says, but he says this is what's usually done. So they end up with this standard of care opinion that we've heard for the first time 2 months after the investigative interview, and it's not based on the regulation, but something else, the standard of care, what people do. That's the problem. What are we responding to? The state's position has been a moving target that by the time we got to the board, they were more concerned with upholding the action that had been taken than really just standing back and saying, wait a minute, let's take a look at this. You know, we're finally able to address these things. Here's what's wrong with the state's position. And the court wouldn't, the board wouldn't hear it.
Well, thank you very much, counsel, for your arguments. Very helpful. We'll take this matter under advisement. We will issue a written decision in due course, and we'll stand in recess to allow the next case to get situated.